Now we can see the chapter Enforcement of Foreign Awards. In this chapter, there are many things which you are going to see. First one is the types of arbitration. What are the different types of arbitration? Second one is types of arbitral awards. In these arbitration, award will be given. What are the types? That also we will be seeing. And then the enforcement of foreign awards. New York Convention and the Geneva Convention that we will be going to see. In this chapter, these two parts which covers the major portion, types of arbitration and the arbitral awards. This is just for clarity purpose. Different types of arbitration are given, but this covers the major portion of the chapter. You need not remember this word by word. You have to just understand the concept, and in these also many similar points are there. It will be very easier for you to see this chapter. Now we can get into the chapter. First thing is types of arbitration. Ad hoc arbitration, institutional, domestic, international, contractual, statutory, fast track, foreign arbitration. In this fast track we already saw in section 29B under the first part of this chapter, arbitration. We saw two sections, 29A for normal timing and 29B fast track procedure. This we will be seeing again in this chapter. The first type of arbitration is ad hoc arbitration. What I will be saying this in a short manner. Every arbitration I will be explaining it short. If you want it in detail, you can go into the details and study this. Now here in this ad hoc arbitration, what is the main thing is the arbitrator. It will be appointed by the parties itself. You will not go to an arbitral institution. We saw arbitral institution like International Chamber of Commerce. You can go to them and appoint the arbitrator. Here the arbitrator will be appointed by the parties itself. You will not go to the arbitral institution. This is the main feature in this arbitration. Here the parties will not dispute. They will arbitrate themselves. They will manage the arbitration themselves. They will itself appoint the arbitrator. They will itself communicate between each other. Everything will be done by themselves only. Here they have greater flexibility. Since the parties are doing all the work, they can do it in a greater flexible manner. They can decide how it should be done. But when you go to an institution, the institution will have the own rules that you have to follow. Here you will have greater flexibility. Now, features we can see one by one. Selection of arbitrator. The parties will by themselves they can choose the arbitrators here. The parties can select a single arbitrator or a panel of arbitrators. They can decide it on their mutual consent. Second one, procedural rules. The parties will be only will be determining the procedural rules applicable for the arbitration. They will have the flexibility. What will be the procedure? They will itself decide. And then administration. Here the parties only will need to do the administrative task. What are the administrative tasks in the arbitration? Hearing date, when the hearing will be happening, document exchange. When one party gives document, we have to verify that it reaches the arbitrator, it reaches the other party. That also we have to verify. And then coordinating communication. If one party gives a message to the arbitrator, it should be clear and proper. That also we should verify. This is all done by the parties itself in the arbitration, ad hoc arbitration. In this, main thing is only all the work is done by the parties. And then flexibility. Since all the work they are doing, they can do it flexibly. And then the cost. Here they only doing all the work. They did not pay fees to the arbitration institution. So it will be very cost effective. And enforceability. The arbitral award is same as the arbitral institution award. If you appoint an arbitral institution also, they will give an award. You itself do all the work, then also they will give an award. There is no difference in the legal status between these two awards. Now, if the award it will be given in arbitration, it will be governed by the law given in the country. There will be national laws, there will be international laws, everything will govern the arbitral award. Now, the next point is expertise of the arbitrator. Since the parties itself appointing the arbitrator, they can decide the expertise. For arbitrator, what he should know, whether he should know related to software or he should be expert in law or that field they can decide, and they can appoint a proper arbitrator. It will be a tailored and specialized approach. Only the parties know in detail about their case. Now they can appoint the arbitrator suitable according to their wish. Level of confidentiality. Only the parties and the arbitrator are involved in the arbitration. There will be a greater level of confidentiality. The summary is that they have a high degree of control and flexibility. It will be suitable for parties who are familiar with the arbitration procedures. There will be parties who have many problems with many clients. Now they will be doing arbitration in many times. So they will be very well familiar with the arbitration procedure. What we should do in our arbitration, what is the first step, what is the second step, how should the award be made, everything the parties know. Now they can do the arbitration themselves. If you do not know the arbitration procedure, then you have to appoint the institution. Otherwise, if you know the procedure, ad hoc arbitration is enough for you. Next type of arbitration which we are going to see is institutional arbitration. In this, we will appoint an arbitral institution. They will do all the administrative work as we saw already, and they will facilitate the communication. They will help to appoint the arbitrator. Many things will be done by the arbitral institution. Here, the features will be given here. The administration, it will be done by the institution, and procedural rules. Since they are an institution, they will have their own set of rules that the parties along with the arbitrator, everyone should be following that rules only. Appointment of arbitrator. The institution will help in the appointment of arbitrator. They will give a list or they will have a specific appointment mechanism. By that procedure, they will appoint the arbitrator. Support of the institution. The institution will help in case management and the administrative tasks like scheduling hearing, managing communication. In that, the institution will help you. And then impartiality. Since there is an institution, both the parties will have to follow the rules of the institution. Both will be given on an equal level playing field. So even if the party knows about the arbitration procedure and the other party does not know about arbitration procedure, there will be no advantage. Both the parties will have to follow the rules of the institution. Now, they will choose the institutional arbitration for the credibility. They will be impartial. They will guide the person who do not know the procedure so that there will be no advantage for the person who already knows the procedure. This they will ensure in the arbitral institution. Now, cost and fees. Since you are choosing an arbitration institution, you have to pay fees to the institution. This will be a little bit higher when compared to the ad hoc arbitration. In ad hoc arbitration, you are doing all the work, no need to pay fees to anybody. The preservation of confidentiality. Here, the arbitration institution, they will have rules, how they should maintain the confidentiality, what will do if they breach the confidentiality, like that, they will have rules. This is important for parties who wish to keep the details private. If you want to keep the details private, you can go to the institution. They will have a procedural framework to keep the details in a confidential manner. Here, institutional arbitration has a structured and efficient dispute resolution approach. It will be done with the support of an institution. It will contribute to reliability, efficiency. The same words are repeated everywhere. You can read this one more time if you want. Here, after completing two types, ad hoc and institutional, they have given a difference. The same point they have given in a tabular column. You can read this if you require. I would recommend not reading this. It is the same thing as given in the above provisions. And then the next type of arbitration is domestic arbitration. What is a domestic arbitration? We already saw in the basics of arbitration chapter. This is a domestic arbitration which occurs in India. The place of arbitration is in India. Then it will be a domestic arbitration. Next type of arbitration we are going to see is domestic arbitration. Here it is given that the domestic arbitration denotes an arbitration which occurs in India. In this arbitration, both the parties must be Indian. As we saw already, there will be two Indian parties. Only then the arbitration will be a domestic arbitration. But here they are also giving that arbitration which occurs in India. How they are deciding that arbitration which occurs in India is a domestic arbitration? It is not given in the express law, but they have understood it by reading the section 2 subsection 2 along with section 2 subsection 7. By reading this together, they are telling that domestic arbitration means an arbitration where the arbitral proceedings must be held in India and according to the Indian law. Two Indian parties, it should be held in India. Indian law should be applied. Like that they are telling. Now, what are the features of domestic arbitration? Rules and regulation. Rules and regulation will be governed by the Indian laws. If it is happening in India, only Indian law will be applicable. Indian arbitration laws will be applicable. Next thing is flexibility in procedure. Since it is happening within the borders of the country, the parties itself can determine the procedure. They can choose the arbitrator, establish the agreement, define the scope of arbitration. Everything the parties itself can do. Valid arbitration agreement is very important for domestic arbitration. The agreement should specify the intent to resolve disputes through arbitration. The agreement should be giving that when we have a dispute, we will resolve through arbitration. We will not go to traditional litigation. Litigation means court case. You should be going to court in case of traditional litigation, but the agreement should specify that you are going to arbitration. The next point is selection of arbitrator. In a domestic arbitration, the parties can select their arbitrators. Number of arbitrators, qualification, method of appointment, everything can be determined by the parties. It will be given in the arbitration agreement. Powers of the tribunal. What are the powers which are given with the arbitral tribunal? It is given in the Indian law. They can make decision on procedural matter, which procedure they can determine. They can consider the evidence. They will give a final award. This is the powers of the tribunal given under Indian law. Awards. Domestic awards are generally enforceable in the same way as court judgment. If a court give a judgment, how that judgment will be implemented? In the same way, the arbitral award will also be implemented. Confidentiality. Confidentiality is a common feature. Under domestic arbitration, it will be very confidential. There are provisions for confidentiality in the Indian law. Cost effectiveness. Domestic arbitration is chose for cost effectiveness and efficiency. When compared to court proceedings, it will be very effective. When we are going to court, it will take many years and it will be very expensive. But arbitration, it is very cheap when compared to court proceedings. Expertise of the arbitrator. The parties, as we said already, in the above types of arbitration, they itself can select the arbitrator who has the expertise in the specific field. And then, it is an informal process. Domestic arbitration proceedings are less formal when compared to court proceedings. These are the points which are given in the domestic arbitration. We already understood these by seeing the Arbitration Act, but this is given in this chapter, so I am reading this once again. The next type of arbitration is international arbitration. As we saw in the Arbitration Act, international commercial arbitration where at least one of the party is outside India. At least one party is from outside India. This is itself given here, where at least one of the parties is involved is domiciled outside India, or the subject matter is related to place outside. Then the arbitration is an international arbitration. It is a method of resolving dispute between parties from different countries or involving cross-border transaction. Either there are different countries and parties involved and cross-border transaction involved, then it is an international arbitration. The features are parties. Parties will be from different countries, or there will be cross-border transactions. They will require a neutral forum for finding the solution. Arbitration agreement is also required here. Same as domestic arbitration, we need a valid arbitration agreement. Now, in that arbitration agreement, it should be written as we will resolve through arbitration. And then impartial forum. We need a neutral forum so that we can avoid the bias. We can avoid a favorable party. Like that, the impartiality will be maintained associated with the national court. If there are two parties, one party is from USA, other party is from India. If the arbitration takes place in India, there may be a chance that the Indian court will be deciding in favor of India. They will give interim measure and many things they will do in favor of Indian person. So for avoiding this, they can select a neutral forum. International arbitration allows parties to choose the governing law. Under section 28 of the Arbitration Act, it is given that under international commercial arbitration, the parties can designate the law. This is given under section number 28. So, by designation, the parties can choose the law according to which they can conduct the arbitration. International arbitration, they can conduct in ad hoc or institutional method. They can appoint the arbitrator themselves, they can do the administrative work themselves, or they can appoint an institution to do all this work. Next point is selection of arbitrator. Here in the international arbitration, parties can select the arbitrator themselves. Now they are chosen for their familiarity with diverse legal systems and cultural backgrounds. Now we can select the arbitrator which has a cultural background, different cultural background. For example, International Chamber for Commerce. They have very experienced lawyers who have saw many cases in international arbitration. They have a diverse legal system knowledge. They have diverse cultural background. You can select them. Like that they are saying confidentiality. Here also same confidentiality related provisions are given. Cultural sensitivity. Since the parties are from different cultural background or different country, we have to give importance to the culture. And witness of the expert. In the international arbitration, if it is related to a specific technical area, the arbitrator can appoint expert to give opinion and give some explanation on the technical or industry specific issues. The next thing is limited grounds for challenge. When it is an international award, you cannot challenge it on many grounds. You have only limited grounds for challenge. Only for certain reasons, you can challenge the arbitration award or arbitrator. Like that, you can challenge only for certain reasons. So, it will lead to a more conclusive resolution. In one way or the other, you will definitely get a conclusion. It is cost effective. It offers a potentially cost effective alternative to litigation. Same, when compared to court, it is very cost effective. Now, as the same, we have given domestic arbitration, international arbitration difference. This you can read it by yourselves. The next thing is contractual arbitration. In this, what is the main thing is, before the dispute arises, when signing the main contract itself, they will also have an arbitration clause. This is the contractual arbitration. By this, what they are saying is, while saying the main contract itself, you have an arbitration contract also. That is why the name is contractual arbitration. Here, the parties choose to incorporate an arbitration clause. This is called contractual arbitration. The features are arbitration clause. It will be included in the arbitration agreement. Freedom of the parties. Parties can decide the arbitration clause according to their wish. Selection of arbitrator. It will be done as per the wish of the parties. Rules of arbitration. They can choose ad hoc or they can also use an arbitral institution. Confidentiality. It will be confidential. Enforceability of arbitration awards. For the arbitration award to be enforced, it will be same way as the judgment of the court. And then speedy resolution. Arbitration clause is added to resolve through arbitration. When compared to court, you can solve it in a quicker manner. Procedural flexibility. You can decide the procedure by yourself. All these are repeated points. If you want, you can pause the video and read it. Next type of arbitration is statutory arbitration. In statutory arbitration, it is imposed by the operation of law. The parties are not choosing it by themselves, but the law is imposing the arbitration on the parties. For example, in the Indian Trust Act, Section 43C provides to deal the dispute to arbitration. Under Section 43C, it is given that that particular dispute should be solved only by arbitration. Now the parties need not enter an arbitration agreement, but the parties have no option but to abide by the law of the land. They have to compulsorily follow arbitration. This is called a statutory arbitration. Here the consent of the parties is not required, but in the earlier types of arbitration, we need the consent of the parties. The parties need to give consent by making the arbitration agreement. Only then we can make the arbitration. The features of the statutory arbitration are: this is based on specific laws. These laws determine the procedure, rules, everything will be determined by the law. Requirement for the valid agreement. They are not entering into an agreement. The law is imposing the agreement on them. It is decided by the statutory provisions. It may include the language required, form of notice, etc. Everything will be given in the law. Types of disputes. Statutory provisions determine the type of disputes to which these provisions will apply. Upon which the statutory arbitration will apply, that will be decided by the law. Selection of the arbitrator. Statutory laws may determine the required qualification for the arbitrator. In case of statutory arbitration, the qualification of the arbitrator will be given in the law. It may also give the formal mechanism to select the arbitrator. There will be a separate mechanism for appointing the arbitrators. Under the law itself, it will be given. Requirement of specific expertise. In some cases, statutory arbitration may provide special expertise. For example, there will be requirement in the law. For specific cases, the arbitrator should have this much qualification. He should have expertise in these fields. Like that, the requirement will be given in law. Confidentiality. The confidentiality provisions will also be given in the law. It will help to maintain the confidentiality. Cost effective. Statutory arbitration are designed to provide a cost effective and alternative dispute resolution to court litigation. When you compare the cost to court, the court litigation will have more cost. But when you take the statutory arbitration, there will be less cost involved. Here we have given a difference between contractual arbitration and statutory arbitration. You can read this if you want. The next type of arbitration is fast track arbitration. Section 29B of the Arbitration and Conciliation Act provides for fast track arbitration. It is a time bound device. The maximum time limit is 6 months, which is given under Section 29B. This is one more very important section which you have to remember. They may ask in exams under what section the fast track arbitration is given. Like that they can ask the questions. The features of the arbitration are accelerated process. Since the time limit is 6 months, the process will be very fast. Limited requirement of documents. Here the decision will be taken not to studying the document line by line. They will focus on the main conclusion of the document and the evidence, whether it is proper or not. They will see it in a holistic manner and it will be decided faster. Simple procedure. There will be a simple procedure. It will have a more focused discovery process and shorter hearings. Within a short number of hearings, the award will be given. Limited number of hearings, and the number and duration of hearings is also limited. The process involves witness testimony and expert presentation to essential matter. When you want an expert presentation, you can order an expert presentation. Selection of arbitrator. Priorities are always given to individual with experience in handling expedited cases. For example, you have two arbitrators. First arbitrator will always solve the cases within 6 months. In all the cases which he have solved in the past, he have decided the matter within 6 months. And we have a second arbitrator. He will take up to 12 months for many cases. Now, which arbitrator we will choose for fast track arbitration? Definitely we will choose the first arbitrator because we have to complete it within 6 months. And short timing process. The timeline is compressed. Under Section 29A, normal arbitration will have up to 12 months. You can also extend it by 6 months. But under Section 29B fast track, the total time limit itself is 6 months. Cost effective. Since it is time bound and within a short period of time it will be completed, the overall cost will be reduced. This will be achieved by combination of limited discovery, shorter timeline. This all will contribute for the cost effectiveness of the fast track procedure. Arbitration awards are final and binding. Same as 29A, 29B fast track procedure awards are also final and binding. There is no difference in the legal status of the award. Flexibility. For an accelerated framework, there is still some flexibility. Even the framework is accelerated, you have to complete within 6 months. Still certain things can be decided by the parties. Specific procedures can be decided by the parties. The next type of arbitration is foreign arbitration. When the seat of the arbitration is outside India, it is a foreign arbitration. And the arbitral award which you are getting from foreign arbitration, it will be a foreign award. The simple thing is, seat is outside India. That is the proceedings conducted outside India. It is a foreign arbitration. Foreign award will be given. That's all. These are the types of the arbitral proceedings. Now we are going to types of arbitral award. In these types of arbitral proceedings, what award will be given? That is given into the next part of the chapter. Ad hoc arbitral awards. When you conduct an ad hoc arbitration, that is the parties itself will do the administrative work, appointment of arbitrator and all, you will get an ad hoc arbitral award. The domestic arbitral award. Under a domestic arbitration, you will get a domestic arbitral award. Here the main point is dispute will be solved within the borders of a single country. Now, the arbitration process is subject to the laws and regulation of a specific country. Only one country laws will be applicable. But in case of international arbitration, cross-border transaction and parties from different country will be involved. So, multiple laws will be followed. In domestic arbitration, only one country law will be followed. And for enforcement of the domestic arbitral award, there will be provision given in the domestic legal system. According to the country's law, you have to implement the arbitral award. The next point is international commercial award. This will be coming out of an international commercial arbitration where at least one party is from outside India. This involves parties from different countries. It will be related to international transaction. It will be used for solving disputes from international transactions. Instead of resorting to national courts, parties often choose arbitration as a method of resolving their dispute, and the resulting award are called international commercial awards. Now the features given are applicable law. Since it is an international award, it will be based on more than one country law. The parties usually agree on the governing law. According to section 28, in an international commercial arbitration, the parties can choose the law according to which the arbitration will take place. This is given here. Arbitration agreement. Here also in the main contract, you should involve an arbitration agreement. And then appointment of arbitrator. In an international commercial arbitration, they will appoint the arbitrator by choosing an institution. This is a very important step. Since it is an international arbitration, they have to appoint a proper arbitrator. He should be independent, impartial. He should have the expertise in the field. Now they will go to arbitral institution for selecting proper arbitrators. Enforcement. Now it is an international award, so the recognition and enforcement will be as per the international conventions like the New York Convention. Now the New York Convention will apply over 160 countries. In this 160 countries, if you make an award in any of these countries, it will be applied as per the New York Convention. So there will be a streamlined enforcement procedure. In all the 160 countries, if you get an award, the enforcement procedure will be the same. Arbitral procedural rules. Here you can have a flexibility in the procedural matters. The parties can decide the procedural specific matters by themselves. Cost and time effectiveness. It will be costlier when compared to domestic arbitration, but it will be cheaper when compared to court. When you go to court, there will be more cost involved. But when you go to international arbitration, the cost will be less. Confidentiality. Here also there will be a confidential provision.